May it please the Court, I'd like to reserve 3 minutes for my rebuttal time, if I may.
3 minutes is granted.
Please. Thank you. My name is Lisa McPherson, and I represent Dr. Galichia, and they are pronounced Mr. Ternes and Dr. Galichia. This case, as most of the cases you hear, is fairly interesting and novel, but it's a little bit odd and ironic at the same time. I represent Dr. Galichia in a medical malpractice case. Mr. Shaddad here represents the accident recovery team and James Klein in a legal malpractice case that Mr. Ternes, the patient in my case, also filed. Mr. Ternes is not here today. He has basically given up. We are here to talk about the medical malpractice case in which the accident recovery team has intervened. The case is ironic in that we've got this medical malpractice case in which Mr. Ternes claims Dr. Galichia did something inappropriate in his care and treatment of him. And he's the only person in that Ternes versus Galichia case that has a claim against Dr. Galichia. However, there was a duty owed, and arguably Mr. Ternes had the ability to bring a lawsuit against Dr. Galichia. However, the irony comes that here I am, standing in front of the Supreme Court of the state of Kansas, arguing on a case which the plaintiff, the one person who has a claim against my client, Dr. Galichia, has agreed with Dr. Galichia that this case should be dismissed and shouldn't have gone beyond the district court level.
But he hasn't given up.
Pardon?
He hasn't given up. He has a malpractice suit against the interveners.
That's true, and that's that other case, and that's my point. I'm essentially, Your Honor, arguing an interlocutory appeal in a different case. This is a good segue into the jurisdictional issue in this case. And, I believe the Court of Appeals erred in finding that they had jurisdiction to hear the appeal. I think that the Court of Appeals erred in finding that the accident recovery team had standing to proceed with the appeal at that level.
How much time at the district court? In reviewing the record, I didn't see much discussion or time given to that question on the question of intervention, and there was a little bit of time spent in the motion to dismiss on the intervention. That seemed to me the only time the court weighed in on intervention.
Well, and that's a good point. Very little time was. And arguably, at the time that the accident recovery team and Mr. Klein moved to intervene into the case, it was probably appropriate. But what the Court of Appeals found in Syllabus 2 of their opinion, they found once an intervener, always an intervener. And what I submit to this court is that absolutely cannot be the law in each and every case, and this case is exactly why. At the time the accident recovery team intervened at the district court level, they had an interest in the case, and they were entering in on the side of the plaintiff to kind of piggyback, if you will, the interests of the plaintiff. And they proceeded to go forward with that interest along with the plaintiff. But as that Diamond case that the United States Supreme Court heard and entered an opinion on, that's not the case that you always maintain that standing. Once once the party on which the intervener intervened, on side they intervened in that Diamond case, left the case, the Supreme Court of the United States found that the intervener no longer had standing. They may have had an interest still in the outcome, but they no longer had the standing to proceed because...
I thought at that hearing at the district court where the intervention was granted, Mr. Ternes didn't enter appearance. He was not present.
The way that is true. He was obviously had filed the suit.
The legal malpractice suit.
And the medical malpractice suit.
Correct.
The motion to intervene came on for hearing before the motion to dismiss. The motion for the intervention took place. The court allowed the intervention at that point. The court then announced that he had received a call from Mr. Levy, the plaintiff's attorney, Mr. Ternes' attorney, that he did not object, was not going to appear at the hearing, and was not going to object to the motion to dismiss. He apparently agreed with my position in that regard. So then we went forward and argued Mr. McElgan, on behalf of the accident recovery team, and Mr. Klein and I argued that case in front of Judge Wilbert, and he made the finding that the case should be dismissed. So there was very little time, but the timing of it was such that the plaintiff hadn't officially folded his tent until after the intervention occurred.
The plaintiff didn't voluntarily dismiss the lawsuit. He still allowed the judge to make a ruling on the motion to dismiss.
Absolutely.
So he was still a party. He was still a party at the time the judge ruled on the motion, and he's still a party on appeal.
Well, I'm not sure he is still on appeal in that he's
Why?
not present here today. He's not. He did not file any brief. He did not enter his appearance at the time of the appeal, and his time to appeal has run. One thing that I agree with the Court of Appeals, and I think everybody that has been involved in this case up to this point has agreed, that the plaintiff acquiesced in that judgment. And so that's part of my argument at this point, is that we have nothing to go back to. I mean, I have a medical malpractice case in which I defend a doctor, and the plaintiff, the one person who has a claim, has acquiesced to the dismissal, and he has let the period of time to appeal or take any action against that dismissal expire. He can't now go back to it. And so with that acquiescence, even if this court agrees with the Court of Appeals and says...
Well, doesn't he have a choice to go forward on the medical malpractice case now?
I don't believe he does, because he acquiesced in the dismissal, and his time to do anything about that dismissal expired. The accident recovery team cannot keep that case alive for him. And that's what he's probably relying on. But I guess to get to the point, which is kind of my third argument in all of this, is regardless of what you decide here today, I believe that Mr. Ternes has acquiesced, he has given up, and that at least after all these briefs, all this time, all this expense, judicial economy mandates that this case be ended here for Dr. Galichia, because the accident recovery team has absolutely no claim, no stake, no ability to sue Dr. Galichia, and Dr. Galichia owed the accident recovery team and Mr. Klein no duty. So they can't proceed and continue with the case at the district court level. So why send it back to the district court? Why give the opportunity for then the judge at the district court level to say, well, maybe you didn't really acquiesce, because then I'm going to be right back up in front of the Court of Appeals, or maybe even you all, saying, hey, I think this is over because the plaintiff has given up.
Is it your present that we don't even reach the merits of the claim because there's nothing to do? There's nothing.
Well, yes, but if you would like to get to the merits, I'm happy to speak of those. To go to that, I want to first look at the saving statute, which is 60-518. That statute has several requirements in order, as you are well aware, to refile a lawsuit that has been dismissed. It has to fail on something other than the merits, which we agree this did. It has to have been commenced timely, which we will get to, because that's part of our issue. Although everybody agrees, including the Court of Appeals, that this case was not timely commenced. And so then the other question is that it has to be refiled within 6 months, which that is. So if you look at this statute, with the plain language of what it takes to refile it, the one that is not present is the failure to commence. And there's no dispute on that. Everybody agrees that this case was not timely commenced. Now, the question becomes, does this statute, does 60-518 mean what it says in its plain, unambiguous language, or are there these unwritten rules that are going to be applied to it, as the Court of Appeals apparently believed when the intervener argued that, meaning, well, you can waive that defense. I submit that's not the case. You cannot waive a defense in one action when it's refiled, and the language of the statute, 6518, doesn't give that opportunity. It's very plain. 3 requirements: timely commenced, refiled within six months, and failure other than on the merits. And we don't have this timely commenced. To go over the timeline very quickly, the first action was filed on March 3rd of 2006. Dr. Galichia was not served. Everybody agrees to that. The 90 days for service expired on June 1, 2006. The first action by any attorney on behalf of Dr. Galichia, the first firm was the Fulton-Siefken firm, and their first action on behalf of Dr. Galichia was on June 28th, 2006. So 27 days after the 90-day period to timely commence this lawsuit expired.
What is the impact of that action in filing a request for medical screening panel?
Well, arguably, it would be an entry of appearance.
Yeah.
And that was an action done on behalf of Dr. Galichia and the Galichia Medical Group, which in that Ternes 1 case was also a defendant and was properly served. The only one that wasn't properly served was Dr. Galichia in that first case. So as you look at this, we're past the time that case could be commenced. If you look at 60-203, you find about the service and the commencement of an action, and you find that you have to serve, of course, within 90 days, or if it's after the 90 days, the case is commenced on the date that the case is actually served or an entry of appearance is made. So in this case was commenced on arguably June 28th, 2006. That is beyond the statute of limitations. The 90 days allows it to relate back to the date of filing. The Court of Appeals said in their opinion a couple times that it wasn't timely filed, and the Court of Appeals seem to use timely commenced and timely filed interchangeably, and I submit that those are not the same thing. Timely commenced is different than timely filed. Everybody agrees this case was filed with the court in a timely manner. It just simply wasn't commenced within the timely manner. So you get back to the plain language of the statute, and you find that there is nothing about waiver. You think about the 7 affirmative defenses that are listed in 6212. One of those, of course, being statute of limitations that was you must raise. There are many others. I will inform you all that Dr. Galichia and his first attorneys failed to file an answer on Dr. Galicia's behalf. And when I took over the case in November of 2006, I didn't realize that had not been done, and I didn't file an answer. The case then was dismissed voluntarily by Mr. Klein, and so an answer was never filed, and everybody agrees that. So arguably, was that defense waived in Ternes 1? Probably so, because that was not raised. However, the part of it is that when you refile an action, you get a do-over, so to speak. And what happens in Ternes 1, unless the court puts conditions on that first dismissal, it doesn't matter in case 2. For instance, if a case is dismissed there was not a defense of failure to state a claim, that doesn't preclude one from raising failure to state a claim upon which relief can be granted in the second suit, in the refiling action. Similarly, people dismiss cases because they need more time to get experts if their deadline has come and gone. And you get a do-over, both plaintiff and defendant, and I would submit that we were entitled to a do-over. And I see that I'm out of time, so unless there are questions.
Just one quick question on the Court of Appeals finding on the waiver. They also mentioned that lengthy discovery had been completed or done, and I'm trying to find where that is. It seemed to me you had a discovery conference, and that's about it.
That is about it. What happened was that Mr. Klein, and no disrespect, but just wasn't moving very much on this case. And so the Fulton-Siefken firm worked very hard to get him moving, to get the case pursued through the screening panel action, and then that's what I took over and tried to do. We ultimately dismissed the screening panel action, and we ultimately then had the case voluntarily dismissed. So it was on file for quite some time.
Filed for some time, but actual discovery, it didn't appear that there was much at all.
Right.
The Court of Appeals kind of thought there were. I mentioned that there was
we
lengthy
had a discovery conference, and I served discovery to which I never received any answers.
Okay.
And that's really about it, other than the screening panel.
Do we have any further questions of counsel?
I do. With respect to the legal malpractice, what struck me immediately is if the defendants there believe Mr. Ternes threw in the towel too easily, why isn't that a defense in the legal malpractice causation or measure of damages? And secondly, does allowing the dismissal without intervening and fighting that have some preclusive effect on the defendants in their legal malpractice. Do you understand what I'm asking you?
I do.
Okay.
And, it does. The decision in my case does have some bearing on the legal malpractice case and the defenses that the accident recovery team can allege or assert. However, the Court of Appeals said if they weren't giving them standing to be in this appeal, they would lose their first line defense. That's not true. They can bring that defense up in their own case. And that's why I said at the very get-go of this is it's almost like I'm arguing an interlocutory appeal from another case. I mean, they can still assert their defense. They can still work toward that. But because the plaintiff gave up, that obviously probably would be a defense too for him, frankly, in the legal malpractice case. We've now got a situation where Dr. Galichia is fighting a ruling for their defense when they have no claim against him to go any further. Does that answer your question? Not really.
That's it. Thank you.
So,
Any further questions?
Well, it would be helpful for your client if we reach the merits and reach them in your favor.
absolutely.
It would be helpful in the legal malpractice case. Even though you're saying we shouldn't reach the merits, if we do reach them in your favor, it would be helpful in the legal malpractice case.
Right.
Well, do you have a dog in that fight?
In the legal malpractice,
Right.
none
Okay.
whatsoever.
Well,
and
that's
frankly,
true. Yeah.
frankly, the accident recovery team doesn't have a dog in my fight, other than what the court decides to rule
It would
as
be
a matter of law.
Right. Sorry.
Any further questions?
I see none. Thank you, counsel.
Thank you.
May it please the court, and just to add another hard name to pronounce, I'm going to throw mine in. It's Todd Shatted for the appellant, and that happened to be the interveners. I don't believe that the intervener issue is a major issue in this case, so I'm going to start with what I think is what this case boils down to, and that's statute of limitations. And the key part of that is statute of limitations is an affirmative defense. And that is the issue in this case. It's an affirmative defense that had to be raised by the defendant. And it was not raised timely, and it was actually waived. And I don't think there's any dispute that it was waived in the first case.
Why can't it be reasserted in the second case?
Because
to me, it seems inconsistent to argue that generally you can raise defenses throughout a case. To not say that it had to be in the first case and not reasserted in the second case.
generally, I think that makes sense, except when you look at the affirmative defense statute, and it says affirmative defenses that aren't raised timely are waived. And if you look at the term or the legal significance of waiver, once it's waived, it's gone. And that's across the entire gamut of the legal world, whether it's in a contract, whether it's procedural. Once you waive something, it's gone.
Would you agree that had the first lawsuit continued, that the doctor could have asserted the statute of limitations up to pretrial?
I would submit they could try, but the problem they had is the waiver didn't occur because they filed an answer and didn't raise the affirmative defense. The waiver occurred because of the action that the doctor took in that underlying case. The filing for a request for a screening panel was the first action that they took, and you are not entitled to a screening panel if your case is time barred. And so that action of saying, I want a screening panel, and I'm going to submit to you a doctor for us on the screening panel, is an action that's so inconsistent with having the defense that this case is time barred that it amounts to a waiver.
Are you raising yet a third trial within a trial? I mean, you indicated that they could try.
Well,
Is that enough? I mean, is the fact that they still could try to have raised the statute of limitations all we need to know?
well,
Or do we
I
have
say
to,
that
do we
is-
have to address the merits of whether that would have succeeded?
No, I don't think you have to. I say that they could try only from the standpoint is you can't. They can do whatever they think they can do, but as a legal matter, I think the facts clearly show a waiver because of asking for the screening panel, and that's an action so inconsistent with making a timely statute of limitations defense, it amounts to them knowingly abandoning that defense. So if the case progressed and they got to pretrial and said they want to put in the pretrial statute of limitations, the argument back would be, and I think the district court found, not because of that, but in their ruling that they waived it, taking the action they did early on in the case was so inconsistent with wanting to use this statute of limitations defense that it was waived. And it creates prejudice, if prejudice is a factor in determining whether there's a waiver, because the defendant or the plaintiff engaged in this case, expended time prosecuting this case when it could have ended early on with a motion to dismiss right out of the chute that said Dr. Galichia was not timely served, it's beyond the statute of limitations, King's X, this case is dismissed.
My other question is, does that matter when you're relying on the saving statute? Because the saving statute doesn't say if a statute of limitations defense could have been asserted or was successfully asserted or anything like that. It just simply says that the first action had to be timely commenced.
It commenced in due time.
In due time.
Right, and it's not really defined. So you go back to, okay, we know what commenced is because that is defined statutorily. And then we look at the statutes and it says, you can get service within 90 days. It relates back. Otherwise, it's when the injury of appearance occurs. And then you look at the statute of limitations statutes that say, you have these windows where you have to commence the action. Well, the fact that statute of limitations is an affirmative defense is the key or critical part of the analysis. It's not something that the plaintiff has to prove. It's something the defendant has to raise. And they have to raise it and timely raise it and prove it. If they have the burden of proof to come in, go ahead.
But when you want the grace bestowed by the saving statute, the burden is on the plaintiff to show that the earlier action was timely commenced.
And by default, because they've waived the statute of limitations, the presumption is, or it's deemed in that case, timely commenced. Because the only way it can be shown that it wasn't timely commenced is if a statute of limitations defense is raised timely and they're successful on it. If they reach their burden of proof, then it's established it wasn't timely commenced. But
but that again depends upon the waiver, and that's the heart of my question: is whether the savings statute builds into it a policy that there would be a waiver. I don't know that it's dependent upon anything that happens in the first suit. The legislature has given the plaintiff the grace of this additional time.
right.
And that speaks to a different public policy, I think.
Well, but it goes back to, when the saving statute obviously references the first case. And so you have to go back to the first case to determine whether it was commenced in due time. And the only way that you can determine whether it was commenced in due time is to see if the statute of limitations has run. But that's a burden for the defendant to raise. If it wasn't an affirmative defense, then I think you're right, and we probably wouldn't be here, because I think it would be on the plaintiff to prove. But since it is and has always been affirmative defense that the other side must raise, because the statute of limitations is protection for the defendant. That's why it's there. It's to protect the defendant from having stale claims come up long after they're relevant and long after witnesses are gone. That's why the statute of limitations defense is there. That's what it's intended to protect. Therefore, they have the burden of proof to raise it. And they chose not to raise it. And they chose to act contrary to raising it. And the court found a waiver. Then you look at, what's the legal effect of a waiver? Well, once something's waived, it cannot be unwaived. You don't get a do-over absent the other party agreeing with that.
And that argument is great if you wanted to continue that lawsuit, but you didn't want to continue that lawsuit. You dismissed that lawsuit, and you started again. And why isn't Justice Byers' statement correct? At that point, you're way out of time, and you have to rely on the statute. And why don't you have the burden at that point to prove you're entitled to an exception to the statute of limitations?
Well, I understand that question. The difficulty I have is it seems to make something simple more complex. There isn't any case support anywhere that I've found. Go ahead.
Let's be simple. You're talking as if the refiled case is simply an extension of the first case. It's really the first case with you getting a timeout is how you're arguing.
Right.
But when you refile, why isn't it a separate case?
Well, it is a separate case.
And is the defendant required to set forth the same defense that was planned for the first
No,
case?
not necessarily.
Well, we have a completely new case, and why can't the defendant choose to use an affirmative defense in the second new case that wasn't asserted in the first case?
I think that as a general principle, you are correct, except the fact that when you have a waiver and you use that legal term waiver, we have to figure out what do we mean by that? Is waiver only temporary in the context of civil procedure? Is it only waiver in the first case? Or is waiver a waiver? I mean, once you waive a provision in the contract, it's waived. It's not dependent on this scenario or that scenario. That provision or that act is waived. To me, it's no different in this arena when you use that same legal term. Once it's waived, and you don't get to go back and, if there's a refiling of the case, start anew with respect to things that have been waived. You can raise a different defense. You can take a different tactic. You may find something that's more relevant, and this is how we're going to handle the defense. But if something's been waived, unless the other party allows you to bring it back in, it's gone forever. And there isn't any case law within this jurisdiction or elsewhere that I've found that says anything different than that. That, well, if you've waived it in the first case, you really haven't waived it in the second. And that would be what you would have to decide in this case, is to plow new ground to say, well, in the context of civil procedure and the saving statute, if you refile a case, then if you waive something in the first case, you kind of wipe the slate clean, and you somehow limit the legal import or effect of the term waiver. And that's what our position is. Once you waive something, it's waived. I think the Court of Appeals agreed with that. I think that's sound legal principle, and it makes cases like this much cleaner, and it also gives significance to the fact that it's an affirmative defense, and the statute clearly says if it's not timely raised, it's waived. And
When
so
the-
that has...
Excuse me, counsel, I'm sorry, I didn't mean to interrupt. When the plaintiff refiles within 6 months, is he or she limited to the exact causes of action that were filed in the first case? Can the plaintiff rethink the facts and file a new cause of action based on the same set of operative facts?
I don't know. The concern I would have is if it's a cause of action that was time barred originally, they probably wouldn't. It's still time barred and it's not saved. For example, if it's a 1-year statute of limitations, like an intentional tort or something along those lines, it wasn't filed in the first case. The second case was filed under saving statute, and they want to bring in a case or a claim that wasn't even ripe or timely filed in the first case.
Well,
I don't think so. But
let's say
I do.
there's no time bar. Let's just say that.
But I think so. Yes, I think it's a do-over across the board. But I think what confuses it or what changes it in this specific issue is the term waiver, and the statute deals with waiver. The statute says waiver. It's not a court-created legal effect. It's something that's in the statute. Now, absent that, I think across the board, when they file a new case, it's effectively a do-over. Except, how do you deal with something that's been waived? Is it temporary? Is it only to the first case? And I think by analogy, you would look at maybe a request for admission statute that talks about requests for admissions or only admissions in that particular case, where it specifically limits an effect of something in a particular case. The affirmative defense statute doesn't have that type of limitation. It just says it's waived. And if something's waived, we have to determine, well, what does that mean and how long is it waived? And can it be unwaived? And do you get a do-over?
Step back to the basic premise that asking for a medical malpractice screening panel waives statute of limitations defense. Could a defendant come into court after a screening panel process, file their answer, assert the defense, and argue to the court that they had chosen the screening panel as what they deemed a more cost-effective mechanism than fighting a motion to dismiss or something, or have another explanation or excuse?
That's a reasonable expectation, except there is case law to the contrary already out there that says you're not entitled to a screening panel if the claim is time barred. And the reason being is the screening panel doesn't deal with anything other than did the doctor deviate from the standard of care. It doesn't deal with the other issues. So if the case law has already established the law of the land that says if you are time barred, you can't even ask for, you're not entitled to a screening panel.
Well, who makes that
So
determination?
why is a null action a waiver?
Why is the what?
A null, you're telling us it's null and void, so why
Well,
is that a waiver?
Because it's a contrary position. I'm not saying that we go back to how is it determined if it's time barred? Statute of limitations is affirmative defense. It has to be raised by the defendant. If the defendant chooses not to raise that defense, which is entirely up to the defendant, then they can ask for a screening panel. But the fact that they asked for it and they didn't file an answer in this case is so inconsistent with wanting to take advantage of affirmative defense of statute of limitations, it amounts to a waiver. And not only that, they named a doctor. They filed a motion to dismiss the screening panel, not because of statute of limitations, but because of lack of prosecution. They asked for a discovery conference. They didn't file a motion to dismiss because of statute of limitations. They submitted discovery, and they didn't do anything in the discovery to suggest that they're raising that defense. So taking the totality of their behavior, it amounts to a waiver because it's so contrary to wanting to take advantage of that.
Part of what's bothering me, frankly, is the opposite, in that even if a defendant might have made a knowing waiver at that point, they did not know that the plaintiff was just going to sit and not prosecute the medical malpractice screening panel at that stage. I mean, and then dismiss, and then wait 6 months. I mean,
Right.
There's a significant lapse of time that has occurred really at the cause of the plaintiff, not the defendant. And I don't know, I mean, just in terms of whether or not that we have to keep the defendant's feet in cement because of a decision they made at that point in time.
Well, it all goes back to analyzing an affirmative defense and when it should be raised, and whether behavior of the plaintiff affects that. And that's kind of what you're getting at. The fact that the plaintiff drug his feet, so to speak, and delayed this case, does that factor in whether there's been a waiver on the part of the defendant on raising an affirmative defense? I think it all is up to the defendant. It doesn't matter what the plaintiff does, because that defense isn't dependent on anything the plaintiff does. That defense is there. And that defense needs to be raised by the defendant regardless of what the plaintiff does, whether the plaintiff prosecutes the case or not. That's a defense that needs to be raised. So I would submit that you don't consider the plaintiff's inaction as part of the analysis of whether there's been a waiver. I noticed that I'm out of time, so any other questions? I'm sorry.
A real quick fact question. The order of dismissal in the first suit had no restrictions, no exceptions, no... sometimes you'll say discovery will be used again or defend,
It didn't have
none
any
of those
that.
stipulations occurred.
None of that. And that, again, is a point raised where yes, you can put that in the journal entry, but we go back to if it's waived, does it need to say that? Is waiver permanent, or is waiver just... The decision you guys will have to make is waiver limited to the case in which it was waived, or is it permanent? That's the main issue.
Well, the decision I want to make is more practical. If we agreed with you, what would happen?
Well, you would remand the case back, and then the plaintiff, I guess,
And we would tell the plaintiff must go forth and fight harder?
No, the plaintiff would come back and have the ability to continue to prosecute the case, but the defendant can come in and say, you acquiesced because of your behavior on appeal. And then the court at that point, the district court, can then dismiss the case based on acquiescence. And this case would go away. I don't think the plaintiff has any intention of prosecuting this case, because if you think about it, what is it easier for the plaintiff in this case? To prosecute a fact-intensive case on medical malpractice, or sue his attorneys if he can get a good ruling that the statute of limitations was botched?
But why didn't he still have the same causation requirement on legal malpractice? Obviously, the act, you had a duty and you breached that duty. That part of it is easier, but he still has to prove damages. And part of the damages now is another level that he has to fight, and that is, hey, you made a choice here and you let the doctor off the hook. So, yeah, we committed malpractice, but your damages didn't flow from that. Your damages flowed in part because you gave up on the doctor's suit.
That's an argument, but in any case, you have both liability and the damage side. Liability is easy in the malpractice case if we botch the statute of limitations. The damage part is where you're talking about, and yes, they could raise that, but
But my point is that's where it belongs. The only reason you're in here fighting is because you don't want to make it easier for the plaintiff to get damages. But why don't you make that fight in your own lawsuit rather than in the doctor's lawsuit? Because this is really a fight between you and your former client, and you're saying you gave up too easy because you wanted to transfer that liability to us that should be on the doctor. Why don't you take that fight where it belongs between you and your former client? Why do we have to go back and make the doctor be in the middle of your fight?
Well, you're absolutely correct on that, and that defense will be raised in that other case. But as a defendant, you're entitled to raise all defenses, and one of the issues is liability. And where is liability determined? It is in this case whether we botched the statute of limitations. And obviously, plaintiff wasn't going to protect our interests in this case, so we came in and said, hey, we didn't botch it, the defendant screwed up, so really there is no liability on us. If we can establish liability doesn't exist, then we've effectively eliminated kind of the question of fact for the jury on how much damages and whether those should be reduced. So you would, in effect, be taking away part of the defense that my client would have, and the purpose behind the intervention statute, which is if there's an interest that needs to be protected and it's not being protected by the existing parties, I have a right to intervene. So to me, it's simple. Take advantage of all the defense we have. We're not here trying to cause Dr. Galichia further liability because I think it's clear plaintiff has acquiesced in that.
But you're saying that when that decision is made by the judge in the med-mal, then that would preclude you from relitigating the issue of the statute of limitations in the legal mal.
That's right.
Okay.
That's right, absolutely.
Okay,
it'd be dispositive of that case because there'd be no liability.
Do you have any further questions of counsel? I see none. Thank you, counsel.
Thank you.
You've reserved 3 minutes for rebuttal.
Yes, thank you. I'd like to focus on this waiver and the language of the statute. As I said before, the statute says what it says, and Mr. Shadid kept talking about the statute says if you waive it, you waive it, and that's not 6518. 6518 doesn't say anything about waiving a statute. For instance, if you would enter a contract with a person and then you go to do another contract, if you waived an issue in the first contract, that doesn't preclude you from putting it in the second contract. And maybe that's a poor analogy, but it's somewhat similar as we have to what we have here. We have a first lawsuit where a defense wasn't raised, and then we get a do-over, and we have the second lawsuit, as Justice Johnson pointed out. And at that point, different things can be raised on both sides. It's the ability to have that new suit. To take this further beyond the statute of limitations and look at those affirmative defenses, like I mentioned earlier, the failure to state a claim, for instance, and the use of the 6518, particularly in medical malpractice cases. As the court's aware, you have to have an expert to go get past summary judgment. Many times, cases will get to the point that the experts don't have opinions on causation or standard of care. And so as a defendant, I'll file a motion for summary judgment. And it has happened more than once that a plaintiff then will dismiss the case without prejudice, like this case was dismissed without prejudice, and then get a different expert or get a new expert if there weren't conditions in that first journal entry, and be able to get past this problematic summary judgment motion that I filed in case 1 and proceed on to trial in case 2. There's really, in my opinion, no difference in that and that grace that's granted to the plaintiff and the ability to do that in those situations as it is in this case, whereas if the statute of limitations wasn't raised at the time, that doesn't carry on to the second that it doesn't carry on to the second case. Similarly, a plaintiff will sometimes forget to serve the healthcare stabilization fund in a medical malpractice case.
Counselor, I think we see your point. What's sauce for the goose is sauce for the gander, is
Okay,
what you're
very
saying. Let me move you to the prejudicial effect of the determination on the question of statute of limitations in the med mal, or the preclusive effect on defendants in the legal malpractice. Because for me, that goes to the issue of intervention, because if there's no harm from that, then why should there be intervention? Why shouldn't the fight be in the case where it's set up?
You mean in the legal malpractice
In the
case?
legal malpractice. But if they would be precluded from fully defending because of what the judge did in the med mal, then we've got a different question, don't we?
I don't think necessarily, because there are two parts to that. It's a very good point, and obviously I've thought a lot about this. One, I don't believe that they are precluded from raising this in the legal malpractice case. There was nothing to prevent the accident recovery team in the legal malpractice case to submit a motion to dismiss that they didn't mess it up because of the issues that we've raised here in the underlying case, and let that judge decide it and take it up to you all in that case. I believe that could have been done as a legal defense. They didn't choose to do that. They also could have attempted to consolidate these cases and go at it that way, which they didn't do. We have two separate cases. And so where we get to that is that maybe at the time they had an interest in it, but as I mentioned before, now that the plaintiff isn't going forward with this, the fact that Dr. Galichia is having to fight the legal issue for their defense with nobody making any claims against him anymore, essentially, just is incredibly, to use the word, unfair, and where I don't think they are precluded from the defense if they didn't fight it at this level. I hope that answers your question.
Counsel, I see you're out of time. Do you have any further questions of counsel? Like 15 seconds to wrap up.
So, yes, thank you, Your Honor. I would say that I believe that the intervener doesn't have standing at this point anymore in this case, and that this case should end for Dr. Galichia at this point. I don't believe any waiver, if there was one in the first case, Ternes 1 transposes into anything in Ternes 2, that 6518 says what it says, and it's very clear. This case was not timely commenced, and therefore they're not entitled to go on with Ternes 2. Thank you so much for letting me be here today.
Thank you, counsel. We thank you both for your arguments this morning. Clerk will take this matter under advisement. We now turn to the second case on this morning's docket. That is case number 102256 and 102257, State of Kansas v. Heather Page Hilton.